Welcome to this deep dive. I am incredibly thrilled to have you here with us today. If you've ever wondered about the exact invisible line between a really bad business deal and a literal felony, well, you are in the right place.
Absolutely.
For our exploration today, I'm going to be acting as your guide. My job is to present the facts, set up the scenarios, and ask the hard, curious questions that, I know you'd be asking if you were sitting right here at the table with us. Beside me is our resident analyst, who is here to provide the rigorous legal breakdown we need to actually make sense of it all.
So glad to be here, and I really love how you frame that, because today we are tackling a very specific, uh, endlessly fascinating legal problem.
Yeah.
How exactly does the law define and punish the illicit acquisition of property?
Right.
We aren't talking about someone pulling a bank heist or, holding up a convenience store. We're talking about trickery, deceit, the art of the con, and dealing in fenced goods.
The white-collar side, or at least the sneaky side of theft.
Hmm.
And to do this, we are focusing intensely on two very specific excerpts from the Model Penal Code. First, Section 223.3, which covers theft by deception, and second, Section 223.6, which covers receiving stolen property.
Exactly. And I want to give you a quick roadmap of the journey we have ahead of us today. We're going to rigorously unpack the black-letter law, but we're going to do it by dissecting human behavior.
Sounds fun.
It is. We'll look at the precise legal definitions of deception. We'll explore something called statutory presumptions of knowledge.
Which sounds heavy.
It's basically how the law catches professional fences, like shady pawnbrokers, even when they play dumb. And crucially, we'll examine the required mens rea, or the criminal state of mind, for these offenses. I'll be breaking these doctrines down element by element, piece by piece, so we can build a comprehensive mental toolkit for you.
So by the end of this, you'll understand exactly how these property crimes are prosecuted. And honestly, you'll probably be a lot better at spotting a scammer yourself.
That is the goal.
Okay, let's unpack this. I want to start with our first doctrinal analysis. When we talk about theft by deception, I think most people just assume it means lying to get someone's money.
Right, yeah.
But the law is usually a lot more specific than that. How exactly does the Model Penal Code define this?
It is highly specific. The general rule, the black-letter law from Section 223.3, states that a person is guilty of theft if he purposely obtains property of another by deception. But the entire weight of that law rests on how we legally define deceive.
Okay.
Under the code, deceiving requires a purposeful, calculated action to do one of four specific things.
Let's go through those four prongs. What is the first one?
The first is creating or reinforcing a false impression. This can be a false impression about the law, about the value of an item, or even about your own intention. You're actively painting a picture of reality that you know is fake.
That makes sense. Active lying. What's the second?
The second is preventing another person from acquiring information which would affect their judgment of a transaction. So this isn't necessarily telling a lie, it's actively blocking the truth.
Like hiding the Carfax report when you sell a used car. Got it.
Mhm.
Prong number three.
Third is failing to correct a previously created false impression. Or, and this is crucial, failing to correct an impression you know is influencing someone to whom you stand in a fiduciary or confidential relationship.
Let's translate that a bit. A fiduciary relationship. That's a relationship built on deep legal trust, right? Like a lawyer and a client, a financial advisor, or maybe close business partners.
Spot on. The law says if you are in a position of high trust, you don't get to just stay silent while your partner operates under a delusion that benefits you. You have an active legal duty to correct them.
And the fourth prong.
Finally, the fourth prong is failing to disclose a known lien, adverse claim, or other legal impediment when you are transferring property in exchange for consideration.
Basically selling someone a house or a car and conveniently forgetting to mention that the bank actually owns half of it.
Precisely. If you exchange encumbered property for money without disclosing the baggage, that's deception.
Now, I have to ask, are there any exceptions built into this? Because I'm thinking about everyday life, and people break promises or exaggerate all the time. Is every single broken promise a theft?
That's a fantastic point, and the code actually anticipates exactly that. There are vital statutory exceptions. First, the law explicitly notes that deception regarding a person's intention to perform a promise cannot be inferred solely from the fact that they didn't subsequently perform it.
Oh, that's interesting. So just because I didn't mow your lawn like I promised, that alone doesn't prove I was trying to con you when I took your money.
Exactly. To be criminal deception, there has to be proof that you never intended to mow the lawn in the first place. A simple breach of contract is for civil court. A calculated con is for criminal court.
Makes sense.
Furthermore, the definition of deceive outright excludes falsity regarding matters that have no pecuniary significance.
Pecuniary meaning financial. So the lie actually has to hit someone in the wallet.
Right. If I lie about my astrological sign while selling you a TV, that lie has no financial bearing on the transaction. The code also explicitly excludes puffing, meaning exaggerated sales statements that are unlikely to deceive ordinary persons. Claiming you make the world's best cup of coffee isn't a crime because an ordinary person knows that's just a marketing pitch.
I see. Well, let's put all these interlocking rules to the test with an actual scenario.
Let's do it.
Let's analyze the case of the silent fiduciary. First, what are the legally dispositive facts?
The essential facts are these. The defendant sold a piece of real estate to an individual with whom he had a pre-existing confidential relationship. During this transaction, the defendant purposely failed to disclose a known, valid lien on the property. So the property was legally encumbered and he stayed completely quiet about it.
And there was a promise too, right?
Yes. Furthermore, just to seal the deal, the defendant verbally promised to perform future landscaping on the property for the buyer, but he never actually did the landscaping.
And what was the core legal issue?
Did the defendant purposely obtain property by deception under MPC Section 223.3 by failing to disclose a lien to a confidential partner and failing to perform a promised service?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied the rule for theft by deception under Section 223.3. The rule has three distinct elements we need to look at here. First, purposeful obtaining of property. Second, deception via failure to correct a false impression in a confidential relationship or failure to disclose a known lien. And third, the limitation that non-performance of a promise alone does not infer deception.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, purposeful obtaining?
We start with a mini-IRAC. The sub-issue is whether his actions count as obtaining property. The sub-rule states that acquiring the consideration in a transaction qualifies. Applying the facts, the defendant exchanged the encumbered property for consideration, actively taking the buyer's purchase money. The court concluded this clearly fulfilled the requirement of purposely obtaining the buyer's property.
Understood. Now what about the second element, deception via non-disclosure?
Here, the sub-issue is whether his silence meets the legal standard for deception. The sub-rule is Section 223.3, prongs 3 and 4. Applying the facts, failing to disclose the valid lien while transferring the property for consideration explicitly satisfies the statute. This is compounded by his failure to correct false impressions given their confidential relationship. The court concluded that weaponizing his silence against a trusting partner absolutely satisfies the deception requirement.
Understood. Now, what about the third element, the unfulfilled promise limitation?
The sub-issue is whether failing to landscape proves deceptive intent. The sub-rule is the statutory carve-out. Deception regarding intention to perform a promise cannot be inferred from the fact alone of non-performance. Applying the facts, the landscaping wasn't done. That's true. But without extra evidence of original deceptive intent, this specific fact alone doesn't prove deception.
Okay, so...
But the court concluded it didn't matter, because the land non-disclosure already completely satisfies the deception requirement anyway.
And after analyzing all the elements, what was the court's final conclusion?
The court found the defendant guilty of theft by deception because the purposeful failure to disclose the legal impediment firmly satisfied the statutory elements, regardless of the unfulfilled landscaping promise.
Wow. Here's where it gets really interesting and a little gross.
Oh boy.
I want to present a visceral, unforgettable hypothetical for you to really illustrate that second prong of Section 221.3, the part about preventing someone from acquiring information. Picture this. A seller is trying to offload an antique, closed wooden casket.
Okay, already a strange transaction.
Right. But it gets worse. Before the buyer arrives, the seller purposely sprays heavy, overpowering perfume all over the room. And when the buyer tries to open the casket to inspect the inside, the seller physically barricades them. He stands in front of it and refuses to let them open the lid. He does this to prevent the buyer from seeing that the interior is entirely infested with a writhing, gross mass of termites and decay.
That is horrifying.
Mm-hmm.
But what's fascinating here from a legal standpoint is how this physically disgusting scenario perfectly encapsulates that exact element of preventing another from acquiring information.
Because he's not actually telling a verbal lie, right? He's not saying this casket is termite-free.
Exactly. It's not a lie. It's an active, purposeful blockage of information that would obviously affect the buyer's judgment in the transaction. By using the perfume and physically blocking the inspection, he is cementing the theft by deception just as solidly as if he had forged a certificate of authenticity.
Okay, so we've covered how the law handles you tricking someone to get their property. But what does this all mean for the other side of the coin? How does the model penal code handle things if the property is already stolen when the actor gets their hands on it?
That brings us to our Lincoln doctrinal analysis. Section 223.6, Receiving Stolen Property. The black-letter law states that a person is guilty of theft if they purposely receive, retain, or dispose of movable property of another, knowing that it has been stolen or believing that it's probably been stolen.
But there's a caveat there, right?
Yes, unless their purpose is to restore it to the owner. We call that the Robin Hood exception.
Let's define some of those terms before we look at a case. What exactly counts as receiving under the code? Do you have to physically hold it in your hands?
Not necessarily. The code defines receiving very broadly. It means acquiring possession, control, title, or even lending on the security of the property, like taking it as collateral for a loan.
Okay, but here's my biggest question. How do you prove what someone knew? If I buy a stolen bike off Craigslist, I can just say, hey, I had no idea it was stolen. How does the law overcome that?
That is the exact problem the drafters faced. Professional fences play dumb. To make this enforceable, the statute explicitly outlines a presumption of knowledge for a dealer, which includes pawnbrokers. For a dealer, knowledge is legally presumed if they meet any of three specific conditions.
So the burden of proof shifts. What are those three conditions?
Condition A, they possess property stolen from two or more persons on separate occasions. Condition B, they received stolen property in another transaction within the prior year. Or, condition C, they acquire the property for a consideration which they know is far below its reasonable value.
Let's see this trap in action. Let's analyze the case of the shady pawnbroker. First, what are the legally dispositive facts?
A licensed pawnbroker acquires a movable safe full of jewels. He pays the seller a consideration he knows is far below the reasonable value of the jewels. Upon inspection, the pawnbroker's shop is found to contain goods stolen from 3 different people on separate occasions. The pawnbroker claims he only took the jewels so he could eventually find the rightful owners.
And what was the core legal issue?
Did the pawnbroker purposely receive stolen movable property with the requisite knowledge under Section 223.6? And does the statutory presumption of knowledge override his claim of intending to restore the property?
What rule of law did the court apply? Please state the full black-letter rule and break it down into its testable elements.
The court applied Section 223.6. The rule has 3 elements. First, purposeful receiving of movable property. Second, presumption of knowledge for a dealer. And third, the affirmative defense of purpose to restore to the owner.
Thank you. Now for the court's elemental analysis. Let's walk through this step by step. How did the court apply the first element, purposeful receiving of movable property?
The sub-issue is whether the item is movable property and was received. The sub-rule defines receiving as acquiring possession or control. Applying the facts, the safe of jewels clearly qualifies as movable property, and acquiring it as a pawnbroker meets the definition of receiving. The court concluded this first element was easily met.
Understood. Now what about the second element, presumption of knowledge for a dealer?
The sub-issue is whether the pawnbroker legally knew or believed the goods were stolen. The sub-rule applies Section 223.6 subsets A and C regarding dealers. Applying the facts, the pawnbroker paid far below reasonable value, triggering subset C, and possessed property stolen from multiple persons on separate occasions, triggering subset A. The court legally concluded that because he hit those metrics, he is presumed to know or believe the jewels were stolen.
Understood. Now what about the third element, the purpose to restore exception?
The sub-issue is whether his stated intent saves him. The sub-rule states the offense doesn't apply if the property is received with purpose to restore it to the owner. Applying the facts, the court weighed the statutory presumption against his uncorroborated claim. They determined his actions, paying a low price to secure goods for his shop, factually contradicted a true purpose to restore. The court concluded his defense failed.
And after analyzing all the elements, what was the court's final conclusion?
The court found the pawnbroker guilty. The statutory presumptions of his knowledge as a dealer firmly established his criminal belief that the property was stolen, nullifying his weak defense of intending to return the movable property.
To really hammer home that dealer presumption and the far below reasonable value element, let's use another visceral hypothetical. Imagine a dealer who specializes in rare biological oddities, macabre stuff.
Right.
A shady figure comes into their shop holding a movable, leaking glass jar. Inside this jar is a stolen, incredibly rare, and deeply gross preserved human brain worth thousands of dollars. The shady figure offers it for $5.
Yuck. But analytically, that is a perfect example. Under Section 223.6, subset C, the sheer absurdity of acquiring this highly specific movable property for $5, far below its reasonable value, automatically triggers the legal presumption that the oddities dealer knew or believed the gross specimen was stolen.
Because $5 is just astronomically cheap for that.
Exactly. The law removes their ability to play naive.
This has been an incredibly rigorous breakdown and honestly a lot of fun. To synthesize everything we've just covered, could you provide a framework for evaluating these kinds of situations?
Absolutely. Think of this as an actionable, step-by-step diagnostic checklist for exam taking or just spotting shady behavior. Here's how you synthesize this entire deep dive into 6 steps.
Lay it on me. Step 1.
Step 1, identify the act. Did the actor obtain property by deception, which is 223.3, or receive stolen movable property, which is 223.6?
Okay. Step 2.
Step 2, if deception, run the 4-prong test. Did they create or reinforce a false impression, prevent information acquisition, fail to correct a fiduciary's false impression, or fail to disclose a lien?
Step 3.
Step 3, check deception exceptions. Is it just an unfulfilled promise? Is it mere pucking to ordinary people? Does it lack pecuniary significance? If yes, no theft.
Step 4.
Step 4, if receiving, check the object and act. Is it movable property? Did they acquire possession, control, title, or lend on security?
Step 5, the trap for the professional fences.
Right. Step 5, run the dealer presumption checklist. Is the actor a dealer or pawnbroker? Did they buy incredibly cheap? Have they received stolen goods within a year? Do they have goods stolen from 2 or more people? If yes to any, presume knowledge.
And finally, step 6.
Step 6, the Robin Hood check. Did the receiver intend to restore the property to its rightful owner? If yes, the theft charge fails.
That checklist is invaluable. As we wrap up this deep dive, I want to leave you with a final thought to mull over, strictly drawn from the source text. Consider the incredibly fine line the law draws between puffing, which the MPC says is unlikely to deceive ordinary persons, and criminal deception.
It's a very blurry line.
It is, and it forces you to wonder, at what exact point does an enthusiastic sales pitch cross the line from legal puffery into a calculated crime that sends someone to prison? Where does the ordinary person end and the victim begin? It's something to think about the next time someone promises you the deal of a lifetime. Thank you so much for joining us, and we'll catch you on the next deep dive.